Hi, welcome back. It's Robin Painter, your friendly neighborhood special education attorney. If you're here, the chances are you're a parent of a child with a disability, or maybe you also work in special education, or you just want to understand your rights under the law. Today we're talking about one of the most important and most misunderstood ideas in all of special education law. It's called the Least Restrictive Environment, or LRE. You may have heard this phrase thrown around in an IEP meeting. Maybe a school told you your child needs to be in a special education classroom or a self-contained environment. Or maybe you've been fighting to keep your child in a general education class with their friends and neighbors and you don't know how to make your case. Either way, this video is for you. By the end of this, you're going to understand what LRE actually means under the federal law, what a landmark case says schools must consider, and the 4 key factors that determine where your child should be educated, and what all of this means when you're sitting at that IEP table. Let's get into it. So first of all, what is LRE? First things first, LRE stands for Least Restrictive Environment. It comes from the federal law that governs special education in the United States, the Individuals with Disabilities Education Act, or IDEA. This law covers every public school in the country. Here's what IDEA actually says. I'm going to read it to you, and then I'm going to break it down. To the maximum extent appropriate, children with disabilities are to be educated with children who are not disabled. And removal from that setting, meaning putting a child in a separate class or school, is only allowed when, quote, the nature or severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So, what does that mean in plain English? It means this. A general education classroom, the regular classroom, is the starting point. That is where the law says your child belongs. The default, the starting place. The school doesn't get to move your child to a more restrictive setting just because it's easier, or because that's how they've always done it, or because they have a program that seems like a good fit. The school can only move your child to a more restrictive setting if they can show that even with extra supports and services, your child cannot make it work in a general education class. So, when you're at the IEP meeting, how do we put this into effect? There is a case that everyone should know about, but we're first going to talk about what restrictive actually means. Think of it like a spectrum. On one end, you have a student who is fully included, spending all day in a regular classroom with their non-disabled peers, maybe with some extra help or accommodations. On the other end, you have a student in a completely separate school for kids with disabilities only. The law says your child should be as far toward that included end of the spectrum as is appropriate for them, not as far toward the separate end as the school finds convenient. This is a really important distinction, and it's one schools get wrong all the time. So now I want to tell you about that court case that I was talking about that changed how schools in the southeastern United States, and actually all of the United States, have to think about LRE. It's called Greer versus Rome City School District. It was decided in 1991 by the 11th Circuit Court of Appeals, which covers Georgia, Florida, and Alabama. Here's the story. A little girl named Christy Greer had Down syndrome. Her parents wanted her educated in her neighborhood school in a regular kindergarten classroom with supports. Rome City School District said no. They said Christy belonged in a special education class. Her parents took them to court. The 11th Circuit sided with the Greers, and in doing so, the court laid out a clear framework, a test that schools in this circuit must use when deciding where to educate a child with a disability. The court said schools have to weigh 4 factors, 4, and we're going to go through each one in detail because they're all important. But before we do, I want you to read something the court said that I think is really powerful. The court wrote, academic achievement is not the only purpose of mainstreaming. Integrating a child with a disability into a general education environment may be beneficial in and of itself. A determination by the school district that a child with a disability will make academic progress more quickly in a self-contained special education environment may not justify educating that child in that environment if the child would receive considerable non-academic benefits such as language and role modeling from association with his or her non-disabled peers. I love this section of Greer because it seems to anticipate what neuroscience and research has now shown us over the years. We are so much smarter than we used to be about these concepts. The court is saying, even if a child might learn faster with regard to certain academic skills in a separate class, that alone is not enough reason to pull them out of a regular classroom. Because school, as we all know, isn't just about test scores and worksheets. It's also about learning how to talk with people, how to relate to your peers, how to make friends, how to be part of a community, and how to navigate the real world. And for a child with a disability, spending time with non-disabled peers teaches all of those things in a way that being in a separate classroom simply cannot. That is the foundation of the Greer decision. And it is the law in the 11th Circuit, which is where I work in the state of Georgia. Next, we should go through the 4 factors that the court said schools must weigh when they are considering whether or not they can remove a child to a more restrictive environment. Here they are. The educational benefits of being in a regular classroom, the non-academic benefits of being with non-disabled peers, the effect on other students in the classroom, and the cost of providing the needed supports. Let's go through each one. Factor 1, educational benefits. Can your child make progress? The first question schools have to ask is, can this child make meaningful progress in a less restrictive environment or a general education classroom? Notice the word meaningful. This is really important. It's not perfect, it's not speedy, and it's not identical to every student. It doesn't have to be at the same pace as a typical peer. It has to be meaningful. Just recently, not so recently anymore, but more recently than 1991, the Supreme Court clarified this in a case called Andrew F. versus Douglas County School District in 2017. So we're almost a decade out from that, but I remember when this case came down, it was huge news. The court said a child's IEP has to be designed to allow them to make progress to meet challenging objectives in light of their own unique circumstances. So what this means practically is that a school cannot pull your child out of a general education class just because your child isn't at grade level, or because they learn more slowly, or because the gap between your child and their peers is widening. A child with a disability will often learn at a different pace than their non-disabled classmates. That is not by itself a reason to remove them from the general education setting. The question is really, is your child making meaningful progress given their circumstances? If they are, this factor supports keeping them included. Factor 2, non-academic benefits, the value of being with peers. This is a huge factor, especially in light of what we know about how children learn and about how we've learned that social functioning and social emotional awareness is actually more predictive of success for many people than academic smarts. The second factor is one that schools often overlook, and that the Greer Court said is just as important as academic progress. It's the non-academic benefits of being in a classroom with typical peers. So what does that mean? Think about everything a child learns just by being around other kids their age. They learn how to have a conversation. They learn social rules, when to talk, when to listen, when to laugh, how to work through disagreements. They learn what's normal behavior for their age group by watching and participating every day. The Greer court specifically mentioned language role modeling as examples. A child with a disability who spends the day around kids who are talking, reading, and engaging, they absorb that. It shapes how they develop. This is really true for students with intellectual disabilities or communication challenges. The research on students with Down syndrome, for example, shows again and again that inclusion with typical peers leads to better communication skills, better social skills, and better long-term outcomes than placement in segregated setting. And here's the thing. A separate special education classroom, no matter how good the teacher is, simply cannot replicate that peer interaction because the typical peer models aren't there. When schools argue that a child will make faster progress in a self-contained setting, parents can push back by pointing to this factor. The question isn't only where will they learn more math, the question is where will they grow most as a whole person. So that is something that really parents should be thinking about it, and IEP teams should be thinking about as well in these meetings. So the third factor the Greer court said that educators and parents must consider is something that doesn't always get named directly, but it is absolutely baked into the law. And this is the possible harm of removing a child from the general education setting. When a child with a disability is pulled out of their neighborhood school, separated from their siblings, their friends, their community, that has a real cost. Think about what it tells the child about themselves. Every day the message is, you don't belong with the other kids. You're different. You need to be somewhere else. Research shows that students with disabilities who are educated in segregated settings have worse outcomes in adulthood, lower rates of employment, less community integration, fewer friendships than students who were educated inclusively. There's also the emotional impact. We know that children who are excluded from typical peer groups are at higher risk for anxiety, depression, and also low self-esteem. And think about the siblings and neighbors at the homeschool. A child who has been moved to a school across town is no longer walking to school with their neighbors. They're no longer in class with their brothers and sisters. They lose taking part in those relationships for a substantial amount of their day and their life. The harm of exclusion is real, and it's documented. And under the Greer framework, it is a factor that must be weighed against whatever benefits a school claims a more restrictive setting would provide. So when a school says, we think your child will do better at our specialized program at another school, parents have every right to ask, what is the real cost of moving my child? What will they lose? Now, this isn't to say that there aren't some programs that would benefit special education children and that would provide a net benefit to the child. The point is that this all needs to be weighed very carefully. The fourth factor is the effect on other students. So the Greer court was pragmatic. They did say that the fourth factor that schools can sometimes use to justify removing a child from general education class is the question of whether the child's presence significantly disrupts the learning of other students. This is a legitimate consideration. If a child's behavior is so disruptive that it makes it impossible for the teacher to teach and for other students to learn, that does matter. But, and this is really important, the bar is significant disruption. Not inconvenience, not extra work for the teacher, not a classroom that runs a little differently. The law requires schools to first try to address any behavioral or learning challenges with supplementary aids and services. Things like a paraprofessional, behavior supports, modified assignments or schedules, assistive technology, before concluding that inclusion simply can't work. If a school hasn't tried these supports or hasn't tried them seriously, they can't credibly claim that a child is too disruptive to be included. And here's another thing to keep in mind. Research consistently shows that the presence of students with disabilities in a general education classroom does not harm the academic achievement of typical peers. In fact, many studies show that inclusive classrooms benefit all students by teaching empathy, flexibility, and different ways of thinking and relating to other people. So if a school raises this concern, ask them, what specific supports have you tried? And what data do you have that those supports haven't worked? So finally, we've been through the 4 factors. We've talked about the Greer Court's decision, and we've defined what a least restrictive environment is. So I want to bring it all together as I get ready to leave you and conclude this video. What do you need to know when you're in that IEP meeting? Number 1, the general education classroom is the legal starting point. It's the default. If the school wants to move your child to a more restrictive setting, the burden is on them to justify it. Not just to you, but also in case they end up in a court. The other thing is that it is not your burden to justify inclusion. Number 2, academic progress is only one piece of the puzzle. Don't let a school convince you that because your child isn't at grade level, they don't belong in a general education class. The law says non-academic benefits matter too. The harm of exclusion matters as well. Number 3, if a school wants to remove your child from general education, ask them what supplementary aids and services they've tried first. Under IDEA, they have to try those supports before concluding that inclusion won't work. Number 4, know the Greer factors. You have the right to ask your school team to address each one in writing. Educational benefits, non-academic benefits, harm of exclusion, as well as effects on other students. All 4 supported with data. And number 5, if your school is in Georgia, Florida, or Alabama, the Greer decision is binding law. It applies directly to your case. If you're outside the 11th Circuit, the principles of this case are still widely recognized and cited. I want to be really clear about something before I close. Least restrictive environment is not a one-size-fits-all rule. There are students for whom a more specialized setting is genuinely the right place. The law recognizes that. The goal isn't to force every child with a disability into a least restrictive setting. By the same token, there are children with disabilities who will be better served in a more inclusive environment. Every child deserves a placement decision that was made just for them, not for the category of disability on file. If you found this helpful, please share it with another parent or educator who needs to hear it. Subscribe if you want more videos like this on special education law, IEP rights, and how to advocate for your child. And if you have a question or any topics you want me to cover, please drop your ideas in the comments. I read all of them. Okay, so this is Robin Painter, your friendly neighborhood special education attorney. I hope you have a wonderful day, and I will see you next time. Thank you. Bye-bye.